Get ready for the dictation. Start. This writ petition has been filed against the award dated 4/10/2019 when the services of respondent number 3 Jagdish Singh were terminated on 17/5/2005. Then an industrial dispute was raised and the appropriate state government on 31/12/2005 made the following reference. The petitioner at the stage of conciliation filed detailed objections on 12/7/2005 stating that the respondent number 3 was not a workman and therefore the reference as was made itself was not maintainable. Against the reference dated 31/12/2005, the petitioner filed a writ petition being writ petition number 17456 of 2006. The writ petition was entertained and an interim order was also passed by which the reference order dated 31/12/2005 was stayed, and on 1/12/2011 this court allowed the writ petition. The operative portion of the order dated 1/12/2011 was as follows. The writ petition accordingly succeeds and is allowed. The impugned order of reference dated 31/12/2005 passed by Deputy Labour Commissioner Saharanpur is hereby quashed. The matter is remitted back to the Deputy Labour Commissioner Saharanpur, respondent number 2, with a direction him to pass a fresh order in the matter in accordance with law and in the light of the observations made herein above within a period of 1 month from the date of production of certified copy of this order before him. The judgment and order dated 1/12/2011 was challenged by means of a special appeal being special appeal number 66 of 2012, wherein on 16/1/2012 it was decided by a division bench of this court that the matter might not go back to the Deputy Labour Commissioner as per the High Court's order dated 1/12/2011, but the Labour Court itself could, before deciding the matter on merits, decide the question as to whether the appellant was a workman. The order passed in the special appeal is being reproduced here as under. The order of the single judge is set aside. The parties may appear before the Labour Court on 12/3/2012 and thereafter the Labour Court may decide the case. It is made clear that the Labour Court, before deciding the case on merit, will decide the question whether the appellant is workman or not. Needless to say that the Labour Court may decide the case expeditiously. In pursuance of the order dated 16/1/2012, again pleadings were exchanged between the parties, documents etc. as were required to be filed were filed. However, when thereafter the impugned award dated 4/10/2019 was passed, the instant writ petition was filed. Learned Counsel for the petitioner has made the following submissions. After the order in the special appeal number 66 of 2012 was passed on 16/1/2012, it was incumbent upon the Labour Court to have first arrived at a conclusion as to whether the respondent number 3 was a workman. Thereafter, it has been submitted by the learned counsel for the petitioner. Separate issues ought to have been framed and parties should have been allowed to lead their evidence. Learned counsel has submitted that the respondent number 3 himself on 3/4/2019 has filed an application which was numbered as paper number 29D, by which it had been prayed that As per the order of the High Court, the initial issue with regard to the fact as to whether the respondent number 3 was a workman or not had to be initially decided on 3/4/2019. Learned counsel for the petitioner pointed out from the order sheet of the case as had been filed with the writ petition that the presiding officer had passed the following order: stop.